This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia.
Afternoon, ladies and gentlemen, and commission members. The Commission on Youth meeting will now come to order. Thank you for joining us, and those who are watching the live stream, thank you for your attention to our important agenda items. The first item on our agenda actually is the conclusion of a 2-year study that the Commission undertook. As the result of legislation, we took a holistic look at the special education processes for parents and, and school administrators to use when it comes to providing services to our children who are on an individual education plan. I'm proud to say that we had 36 members on that advisory committee representing numerous organizations and stakeholder groups. It was a very comprehensive process. I know many of you in the audience actually participated in some of the breakout groups or public comment that the advisory committee held to get to this point. I just want to note that the item before us is a study, and it is the conclusion of our work. It is not a legislative agenda. Amy Atkinson will walk us through the recommendations that are in the study, but I believe only one actually will require legislation from this committee. Just so everybody knows, the study, as we were directed, will be sent along to the authorizing committees that have authority over education and health in both bodies, in the Senate chamber and in the House delegates. And at that point, lawmakers, after reviewing the study, may decide to put in legislation or may take what we have done and tweak it and do something very different with it. So this is the very, very beginning. I will have Amy make a presentation, and then I'll make a few remarks about our expectations of public comment. Amy.
Madam Chair and members of the committee, I would like to draw your attention to the decision matrix for the review of Virginia's special education resolution system found on the right side of your folder. These recommendations, as Madam Chair stated, are the results of a 2-year study with the assistance of an advisory group of 36 stakeholders. As there is a long list of members of the public who have signed up to give public comment, I will be brief. On the left side of the decision matrix are the draft recommendations. You will see in red any changes that were made based on written public comment received. On the right side of the matrix, you will see a summary of the written public comment received by the deadline of October 15th. I would like to highlight Recommendation 20 on page 17 of the matrix. Recommendation 20, if adopted, would require legislation. This recommendation would relocate the parent ombudsman for special education, which is currently located at the Virginia Department of Education, to the Office of the Children's Ombudsman, which is a separate entity that reports directly to the governor. Also note that while the Virginia Council of Administrators of Special Education opposed this recommendation, Recommendation 20 was well received and supported by others who provided written public comment. Next, I would like to highlight Recommendation 22. There were several people from the public who expressed opposition to this recommendation. On page 19, you will see an alternative recommendation, option B, that requests the Virginia Department of Education to report to the Standing General Assembly Education Committees data on the number of hearing officers' dismissals based on vexatious and repetitive complaints before the 2027 General Assembly session, as this law enacted expires July 1 in 2027. And Senator Favola, that concludes my remarks.
Thank you, Amy. Before I go further, I think I want to take a roll call just to make sure we have a quorum. Colleagues, the roll is going to open. I think you're going to have to do a voice roll call. My apologies, Will. Okay.
Madam Chair, Senator Favola.
Say your here.
Here.
Delegate Carrie Coyner.
Here.
Delegate Delaney. Delegate Seabolt.
Here.
Delegate Shin. Delegate Tatum.
Here.
Senator Marston.
Here.
Senator Suderline.
Yes.
Citizen Member Mackenzie Babachenko. Citizen Member Rita Jones. Madam Chair, you have a quorum.
Thank you. Before we turn to public comment, I will note that several members of the Commission on Youth devoted a fair amount of time and energy to the report before us, and I'd like to thank Delegates Coyner, Delegates Shin, and Delegates Shebolt, and Delegate Cole. So thank you for your work, and we appreciate your input. Before we vote on the report, we will take public comment. There are just a few rules I'd like to articulate so we all enjoy each other's company. We will ask that the speakers keep their comments to 2 minutes, please. And a buzzer will go off warning you that your 2 minutes is about to expire. We know that this is a very important issue to many of you, and it's an important issue to those of us on this side of the dais. We are all here in good faith, and accordingly, we would very much appreciate if no member of the commission or no lawmaker is called out publicly in any fashion during your public comment. And we ask that your tone be as civil as possible. Those are the rules that we abide by in all of our Senate hearings, and I expect there are similar rules in the House of Delegates. So thank you for coming, and thank you if you have provided written comments and you're not here, but you are here in person. I will go ahead and call out the first speaker, Cheryl Wilson.
Hi, yes. How's everybody doing?
Good afternoon.
My grandson attended Henrico High School, and your dispute resolution as far as the hearing officers, we were the prevailing party in that due process. What I have came to terms with is delay and deny, delay and deny, delay and deny, and this has cost my grandson his public education. 100% of Henrico's African-American males are referred over to law enforcement. 100% per the Office of Civil Rights. I want to look at all of you in here because these are our black children, our black male men that are losing before they can even get into an adulthood. So I want to know on every level, because my delegate is not here today, what are we planning to do about the disparity that's going on in Henrico County? It is beyond my belief because I'm here from Atlanta. I lived in counties that were triple Henrico. They're not third in the nation. They're not sending 100% of their black boys to prison. And then I get a hearing officer that prevails and then put a stay put for me to send them back into the same environment that abused him. Where they do that at? But thanks to my grandson and my family being educators and Dr. Candace Lucas, my grandson was able to graduate with a 3.6 grade average with an IEP. So I'm not going to stop until Henrico stops sending our boys to prison. And congressmen and legislators continue to allow this to happen. I don't know how you sleep at night. But by the grace of God, I'm going to fight it all the way to the Supreme Court. And yes, your hearing officers are not with our children, because there's no way I would have sent my son back, my grandson, back into an environment that abused him.
Hey, good afternoon. My name is Jackie Apt, and I am here today to share my personal experience having a child in Henrico County Public Schools for the past 6 years. My hope in sharing this account today is to shine light on the areas of opportunity to improve the IEP and dispute resolution process. Reading, and his autism impacts him primarily with expressive communication and with his social skills. Ari's educational needs have not been met in Henrico County Public Schools. Specific areas of concern are reading and writing, in which his annual IEP goals and reading level, which is a pre-primer level 1, you would typically see that in kindergarten, have not advanced at all, but have remained exactly the same in the 6 continuous years he has attended Henrico County Public Schools. This lack of evolution is counter to the progress reports Ari has received indicating sufficient progress or mastery of these goals. In an IEP meeting of February of this year, I asked the IEP team how they plan to amend the current approach to allow Ari to see results. Frustratingly, after waiting several months, we were told that we needed to wait and see and that they needed more time to collect more data. The same answer we have gotten from Henrico County Public Schools to my son's detriment for the past 6 years. We have taken every action we know on our part, but need something to improve systemically. We hired an advocate to help us navigate the complex IEP and dispute resolution process and ultimately influence Henrico County Public Schools to meet their legal obligation in providing Ari with the education he is entitled to. We've requested private day placement due to lack of progress 2 times in the past 6 months, and we have been denied both times. And we are now in the state complaint process, which includes mediation, in hopes that Henrico County Public Schools will do the right thing and provide him with the education he's entitled to. Having exhausted all options except legal action, I'm here today with the, sorry. Thanks.
Thank you. Minister Cheryl Sims.
The time already started. Can you start it back over? The time is already clocking down. I hadn't even got up here. Good afternoon, everybody. First, giving honors to my Lord and Savior Jesus Christ. I'm Minister Cheryl Sims from Goochland, Virginia. I stand before you as a parent, a grandparent, and a victim of the wreckage caused by House Bill 2606, pushed by Delegate Lee Ware and Mike Asap, a former Chesterfield County administrator fired for denying disabled children the basic right of transportation to and from school. HB 2606 is not protection, it's lawfare. Major General Charles Dunlop defined lawfare as the use of law as a weapon of war. Scholars described it as abuse of court and media to destroy opponents, the weaponization of litigation by the power to crush the powerless, the powerful to crush the powerless. That is exactly what HB 2606 does. It hands already biased hearing officers the power to dismiss parents' complaints as repetitive or vexatious. My grandchildren were some of the worst cases that they've seen in the state of Virginia, maybe the United States of America. They watched their mother get murdered. They were abused, traumatized, and they're disabled on top of it. And Virginia's own Merced report submitted July the 1st confirms what families have been shouting for years. The system is broken, its execution falls short, hearing officers show extreme vulnerability, and there is persistent perception of bias against parents. Instead of fixing those failures, HB 2606 weaponized them and silenced families. It strips us of our constitutional rights. The 14th Amendment promises us no state shall be deprived any person life, liberty, or property without due process of law. HB 2606 tramples those promises. We see this damage done everywhere with Zerrick Jackson. We see it with my grandchildren. We see it with the Wilson's grandson. We see it all over the place. This is corruption. God has sent me to this place to tell you he sent Moses to talk to the people of Egypt. I come to talk to you and let you know I will not stop fighting because that I am sent me to fight this fight. Thank you.
Next is Liz Fuller.
I'm a pro bono special education attorney who has seen firsthand how Virginia does not comply with IDEA or even our own regulations when it comes to the special education due process system. Indeed, if the legislature today does not adopt the recommendations of Mr. Merced, whose report clearly laid out the desperate need for reform to the due process system and oversight and compliance mechanisms for the Virginia Department of Education, you should instead rename 8 Virginia Code 2081-210 because to call our due process system impartial in Virginia is a lie. The truth is that the same hearing officers who have ruled against 99% of parents in the past 20 years, as reported by the Hear Our Voices federal lawsuit, are far from impartial. In my experience, they have given blind deference to the LEA witnesses, excluded testimony and evidence from the parents, have gone on the record without me as counsel, threatened to kick me out of a hearing for calling out bias when deciding objections, and have put every roadblock in the way of parents from receiving justice for their disabled children. For this reason, these hearing officers need reform, and today I implore you to adopt the recommendations of Mr. Merced to require them all to be recertified and trained on the law. Now more than ever, when special education funding is being mismanaged by the local jurisdictions and they're forced to give back millions, and the OSEP has been reduced to next to nothing, the Virginia legislature must accept the charge to make things right. Mr. Merced has independently and objectively informed you that in Virginia, IDEA is not being implemented, and there is a severe lack of oversight by the Virginia Department of Education. There must be teeth behind the corrective action plans and oversights for the dispute resolution and due process systems. Now is your opportunity to bring Virginia out of the 1950s to provide the civil rights that are guaranteed to our most vulnerable families and students with disabilities under IDEA. You have the once-in-a-lifetime chance to make things right for the parents who have mortgaged their homes and cashed out their retirements in a failed attempt to simply get their children the free education that their tax dollars fund, but that they do not benefit from this current compromise system.
Thank you for your remarks. Clearly, you read the report. Next is Brittany Robinson.
Good morning, Chair and members of the Commission. My name is Brittany Robinson. I'm a Virginia mom of 4 disabled students with IEPs in Prince William County schools. And I'm a parent advocate who has spent years in due process and federal court because this system does not protect children like mine. I'm here today because what is written in the Merced report is not abstract, it is my life. My son Ranger is autistic, gifted, and has trauma from school-based failure. When the public school system could not meet his needs, we were shown private day school options by Prince William County. What we saw on these tours was alarming. The school that they selected for him was a behavioral program that included 5 magnetically locked rooms where children are placed in seclusion and restrained when overwhelmed. This is what Prince William County called FAPE in Virginia. So I worked with his medical providers and therapists and found him a real solution. I placed him at the Linder Academy, a small trauma-informed school for gifted and twice exceptional learners that allows for gen ed peers. Prince William County refused, so I had no choice but to file a due process to keep my son safe. I took, in that due process, hearing officer Robert Hartso was selected, and I lost that due process. I appealed that decision in federal court. This year, Ranger was placed at Linder Academy, and he had over 95% attendance, near perfect grades, and finally feels safe. I was forced back again into due process a second time, and guess which hearing officer was randomly selected to be faced a second time? Mr. Hartso. Tell me how this is fair at all. It was not fair. It was not fair not because the law or facts were against us, but because the system is designed to break families before they can protect the children. And even when families like me survive a hearing, it doesn't end with a decision. It ends with compliance. That is where children are abandoned. Prince William County delays, ignores orders, withholds reimbursement and services, and nothing happens. There is no enforcement.
Good afternoon, Madam Chair and committee members. My daughter was found eligible for special education in the 2nd grade for autism and speech and language deficits. For years, I trusted the system. I believed her high grades meant she was progressing. But behind those grades were IEP meetings filled with jargon and empty promises to quote-unquote follow up. I later learned she was performing on a 3rd grade level in reading and math as she entered 6th grade. She is now a 9th grader. And still on 3rd grade levels. When I began asking for real support, I was met with opposition instead of collaboration. I went through due process where, despite clear evidence that my daughter made no progress, the ruling favored Prince William County schools. The one decision that we did win still hasn't been honored. The compliance process is ineffective. There is no accountability when districts ignore hearing officer decisions or violate timelines. Parents are left fighting a system that polices itself and always protects itself. My daughter is a bright girl who deserves an education that lifts her up, not one that holds her back. But the system is broken. It fails the very children it claims to serve. This isn't just about one family. It's about a structure that needs to be rebuilt. Policies without reinforcement mean nothing. Families shouldn't have to exhaust their savings or their sanity just to make sure schools follow the law. It's time to revamp the system to create real accountability, real compliance, and real consequences when schools fail to provide the free and appropriate education every child is promised under IDEA. Our children's future depend on more than words. They depend on change. I charge the Commonwealth of Virginia to immediately implement all draft recommendations of Virginia's Special Education Dispute Resolution System. Thank you.
The last speaker on our sign-up sheet is Candace.
She signed up. There's one that was left off the list. Can you stop my time, please?
Yes, your time is starting at 0 right now.
You guys see the graveyard behind me. Once again, my name is Dr. Candace Lucas. I am an advocate, licensed educator, licensed special educator, licensed administrator. And I hear the word be civil so much from elected officials that it's time to be civil. You are not allowed to tell us to be civil when you violate our civil rights as a pattern in practice. This committee, which is all white right now, reflects the report that you received, where it was less than, what, less than 2%, 3% of color individuals. You said it represented all these people. No, it didn't. You've been bamboozled. You've been totally robbed because it didn't represent everybody. And that was intentional because the committee was created, HB 2606, was created to stop me, a Black woman who can beat big law firms in due process, legitimately. It was created under false pretenses. It was created under ill will. When you have incompetent hearing officers who I have to tell, get the handbook out. I have to get their administrative handbook out and tell them what page to go on. And you're sitting here saying people like Mike Asep and Sands Anderson and all these other people who don't want to lose. They don't want to lose. They want to keep making money prostituting and exploiting our Black and brown children and our children with disabilities. This is human trafficking, and you've allowed it to happen. To perpetuate that this system is not being dismantled is a problem. He told you needed, Merced said, get rid of the hearing officers. Get rid of them. They are harming children and families, and you're sitting here like nothing's happening. The governor can do an executive order for keeping people out of the bathroom. He can do one for this. The hearing officers are incompetent, they're negligent, they should lose their licenses. Would you allow a surgeon to continue to operate on children when someone told you that surgeon is incompetent? No, you would not. I expect accountability and I expect integrity, and we don't have either right now. So you need to step up, Virginia. She signed up. Yeah.
I signed up and got confirmation. I received confirmation back. I am not. Thank you. Good afternoon, Madam Chair and committee members. My name is Janice Rookwood Jackson. Since December 2023, I have filed multiple actions to challenge misconduct and retaliation affecting my children's education. These include over 30 IDEA due process complaints addressing denial of FAPE, unauthorized meetings, and unlicensed staff, nearly 10 notices of intent to sue for retaliation and lawfare seeking $10 million in damages and advocacy restoration, 7 insurance claims against school personnel for harassment, deception, and unlicensed practice with over $12 million in damages sought, police misconduct, complaints related to the school resource officer, totaling $1.5 million in claims, more than 25 procedural safeguard objections citing clear federal and state violations demanding $7 million in relief. I have nearly 800 pages of evidence and documents supporting compensatory education claims totaling $12 million in damages. The message is clear. The system is on notice. Parents will no longer be silenced or ignored. So I challenge this committee to mandate independent oversight of special education statewide and hold agencies accountable for retaliation and obstruction. Every filing and every claim I make is not just paperwork. It's a trail of accountability for every official, educator, and agency who thinks they are above the law. I say to you, you have now been served. Thank you.
Thank you, Madam Chair, members of the committee. My name is Mike Asep. I am working with the Virginia Council of Administrators of Special Education. VCASE generally supports those initiatives that we've talked about, early dispute resolution, because due process is should be avoided at all costs because it is challenging legally as a process. So we appreciate the information, the training of parents, the training of staff. In fact, right now in Williamsburg, there are 600 general and special education administrators together getting training in specially designed instruction in students in inclusive settings. So we believe in working and building capacity for our students, serving our students with disability. So you've seen the concerns we have around some of the recommendations, but we do appreciate your work with talking about mediators, training for mediators and supervision of those. We talk about due process hearings where we are appreciative as school division members that the burden of proof remains on the complainant for those. We strongly believe that there should explore licensure and certification of non-attorney advocates and regarding ethical conduct in meetings. So we look forward to that, and we certainly appreciate the Commission's recommendation regarding HB 2606. Well, let's look at it. We have a couple of years to make some final decisions. So we strongly favor facilitated IEPs. It empowers participants in meetings, and we appreciate those recommendations. We want informed parents and provided with all the resources they need to reach agreements in early stages as possible, so early dispute resolution. We thank you for your time and appreciate Mr. Egan and Ms. Atkinson for their work with the committee. Thank you so much.
This time, colleagues, it is important that we move the study forward, so we will need a motion for that, and then we can talk about two specific items that I think merit individual attention. Ms. Coyner.
Thank you, Madam Chair. Looking at the experience that I've had in working in the Special Education Dispute Resolution Advisory Committee and working specifically with one of the small groups, we have put a lot of work, not just in this work group, but outside of it I've put a lot of time and effort. I will be the first to say the recommendations are not perfect, but they are a step in the right direction, and these recommendations do need to keep moving forward. I would move that the amended recommendations, what we see based on the changes to public comment, as well as in recommendation 22, the option B instead of the original, what's in red, option B would be moved forward. And I so move that those recommendations be included in our November 1st report to the governor and the General Assembly. And I'll give everybody a moment to find that.
I appreciate that motion. I think that's where we need to be at this moment. Again, as I explained earlier, this is the very beginning of the process. We will see legislation perhaps, we will see budget amendments, there will be more opportunity for comment. It is absolutely a step in the right direction. So I would like a second to that motion. There was a second, Delegate Tata. Okay. We did take copious notes on what the speakers presented to us, and we do know that structurally we can make changes. I hope that our structural changes will, in effect, make a real difference in our schools and how the IEP process, how the facilitated process is actually conducted. I do want to point out that I am most proud of the committee's work on, I think it's page 20, recommendation 20, where we really now will put in legislation to create a parent advocate slot in the Children's Ombudsman Office. The Children's Ombudsman Office is separate and apart from the Virginia Department of Education. Mr. Reynolds serves as our Children's Ombudsman and has for a number of years. And this will be a more objective opportunity for the display of information and perhaps the technical assistance that some parents might be looking at. So I'm very excited about that. I will be asking commission members, some of them, to carry this legislation. I will commit myself to carrying it, and we will go forward with a budget amendment on that. So that's a good step in the right direction, and that was one recommendation where we actually had a lot of unanimous agreement on, as I recall. And there's no other recommendation in here that absolutely requires legislation. Some are going to require budget amendments, and I know I will probably carry most of those budget amendments. So we'll work very hard to make the structural changes that we need to make. Any other comments, colleagues, on the motion before us? Delegate Coiner and then Delegate Seabolt. Oh, okay, Delegate Coiner.
Thank you, Madam Chair. I will say, again, not perfect, steps in the right direction on moving recommendations from the report forward. And we continue to have work to do on legislation that does make additional changes. I looked through, I read all 150 pages worth of written comments. So if you submitted a written comment and weren't here to publicly speak, I read, I took notes, I have things printed out from those, and there is still work to be done based on those individual comments. Teeth behind compliance and enforcement is another step that we need to do. I understand when parents and caregivers and advocates stand up, and the tone is anger because it's justified. I mean, that's just the truth, right? It is justified because these are your kids and a system is broken that is not benefiting them, and in a lot of instances is hurting them. And I understand that. And my commitment is to continue to work on the legislative side. These are budget amendments that are going to put money and put the resources in place. But one area that I continue to say we need to fix are hearing officers, right? We need to start from ground zero. And my personal opinion, as everybody needs to restart. But that is an area, if you read through all the comments, you read through the transcripts of hearings, that we do consistently have problems. There is a reason if you hear the same hearing officer name brought up over and over and over again, there is a problem there. It is not lost on me. But again, this report is broader. It doesn't have some of those specific items. And my hope is that everyone involved who wants the system to be better for kids continues to work on the details behind the bigger picture. We have an outline here of what needs to happen and things that say this should happen and that should happen. It will take everyone following behind the recommendations and hopefully the budget money, as the senator so aptly put, that follows behind these changes to make sure that it happens. My commitment is I will keep walking alongside those of you who are working as attorneys, working as advocates, and family members advocating for your own kids, that what this report outlines are the shoulds become shalls, that it happens, okay? So we will continue to work on legislation. That hearing officer piece, again, I hear you loud and clear that we need to make sure that happens. Thank you, Madam Chair.
Thank you. Okay, colleagues, I don't see anybody else in the speaking queue. We do have a motion before us, so I'm going to ask the clerk to call the roll, please.
Madam Chair,
Aye.
Delegate Coiner,
Aye.
Delegate Seabolt, Delegate Shin,
Aye.
Delegate Tata,
Aye.
Senator Marston,
Aye.
Senator Suderline,
Yes.
Citizen Member Babachenko.
Yes.
The motion passes.
Thank you. It passed unanimously. That says a lot about our willingness to be bipartisan and our willingness to roll up our sleeves and really serve the families and children of Virginia. So thank you. And again, thank you to all who participated in making this report a reality. We will work very hard, as was mentioned earlier, to get to the detail and to really make the systemic changes that we need to make. So Let's move on, colleagues, to item 2, which is a review of Virginia Special Ed, hold on. That's not item 2. It's the inpatient treatment to a public school. This was, I believe, a bill that came to us from last year. Okay. Inpatient treatment to a public school decision matrix that had to do with the sharing of information.
Yes.
Will, go ahead.
Thank you, Madam Chair. So the Commission received 5 public comments on this study that you'll see on your matrix, 1 from a UVA professor, 1 from a parent, and 3 from stakeholders who participated in this study earlier this summer and helped work on Senate Bill 1143 that was filed this year in 2025. So as a reminder, this Senate bill was introduced by Senator Obenshain and co-patroned by Senator Favola during the 2025 session. This bill amended the code to direct mental health inpatient facilities to share portions of a minor's discharge plan with the school's mental health professional or school counselor. So this sharing should be done such that if the facility deems that such discharge poses a threat of violence or physical harm to himself or others, and that the minor needs additional educational services. Recommendation 1 that you see on your matrix differs from the 2025 legislation introduced by making the primary focus the educational services. Recommendation 1 was revised to share discharge plans based on the fact that the minor was originally admitted because the minor posed a threat of violence or physical harm, rather than being based on if the minor poses a threat at discharge. 2 public comments were received on this part of the recommendation, and I'll discuss them shortly. Finally, recommendation 1 includes an enactment clause directing DOE to create guidelines to place safeguards around proper use of information obtained by the schools, and that piece was not in the original legislation in 2025. So now briefly, I'll go through the comments. The changes, like the previous matrix, are in red, and to help the members of the commission, you can find a clean copy of these 2 recommendations on the green piece of paper in your folder. So the first public comment was from Dr. Henderson Smith and Natalie Hedrickson of UVA. They signed a letter and commented on the 2025 legislation that SB 1143 narrows the scope of what information should be shared with schools and who it should be shared with, and it also gives parents more rights by including provisions for notification and right to refusal. The letter also states that the use of the term discharge plan may be limiting for several reasons. It may be more meaningful to explicitly state the type of information that hospitals should share with school, regardless of the name of the document. So based on this feedback, staff added language to recommendations 1 and 2 that states, in quotes, "and or related discharge documents" when the term discharge plan appears. This addition is in red and was put in to provide more clarity. The Virginia Hospital and Healthcare Association provided public comment that sharing discharge details rather on admission criteria rather than discharge status may misrepresent the student's current condition and progress. VHHA further went on to comment that we suggest amending the bill to require the disclosure of discharge plans only when active safety concerns or educational needs exist. The Legal Aid Justice Center made similar comments to this. This would put the recommendation back in the posture of the 2025 legislation. So based on this feedback, staff placed back in language from the original bill that states relative portions of the discharge plan shall be shared only if the facility determines that the minor poses a risk of violence or physical harm to self or others at the time of discharge. Yes, that is the amended recommendation in red and on the green copy. And so to kind of explain this back and forth a little bit to you, so you may recall at the last meeting that this language was not included, and that is because before this went out for public comment, we heard input from stakeholders over the summer, including the VHHA, that essentially a facility would not discharge a minor if they still posed a risk of violence or harm at the time of discharge. So taking these two pieces together, if this recommendation moves forward, commission staff will work with the hospitals to ensure that the disclosure of discharge plans when active safety concerns exist has an actionable and clear meaning. So additionally, VHHA includes suggestions for procedures for handling sensitive information, training, and templates. Further comments are from the Legal Aid Justice Center, and they oppose recommendation 1 and would support recommendation 2 with changes, which I'll get to in a minute. LAJC states that recommendation 1, for that recommendation, discharge records often contain highly sensitive information, and additionally, discharge records may contain information that is very subjective. The Virginia Association of Community Services Boards asserts that both recommendations potentially violate HIPAA. VACSB states that HIPAA allows disclosures only when the statute explicitly mandates release, defines the specific information and recipient, and limits the purpose to what is strictly necessary. Their comment goes on to explain that the HIPAA required by law exception does not apply to recommendation 1 because it still grants facilities discretion and relies on an opt-out model rather than explicit parental authorization. So VACSB's comments highlight the fact that exceptions to HIPAA are permitted under the law, but limits to drawing those exceptions exist. Now, over the past 2 legislative sessions that this was introduced, concerns about alignment with HIPAA were not explicitly raised by stakeholders. To address this issue today, though, staff added language to recommendations 1 and 2, stating that sharing of information shall be done as permitted by federal law. Now, based on staff's conversations with the Division of Legislative Services, the current recommendations may be read as a disclosure that is required by law, in this case, in the format of a conditional requirement. However, commission staff, or DLS, have not been able to find case law or secondary analysis that is specific to the scenario described by the comments. Another option to address the comments by VACSB would be to make the parent opt-out an upfront authorization by parents. If this recommendation goes forward, staff will work with DLS and hospitals on creating a process that complies with HIPAA. So moving on now to recommendation 2, I think it would be helpful to describe both of them first because it's recommendation 1 or 2 as described in the handout and in the matrix. So if the commission is interested in either of these recommendations, then members would want to adopt either 1 or 2 with any amendments that they desired. So for recommendation 2, the difference is instead of sharing the discharge plan with the school, the hospital would simply provide notice to the school about the student's discharge from the inpatient facility. This would be done instead of providing the discharge plan, and it would then be incumbent upon the school to work with the parents on accessing any discharge plans. The mechanics of sharing this information and the parental opt-out and reasons for disclosure are written the same as recommendation 1. So they're parallel in most other respects, but sharing the discharge plan versus just a notice. So for recommendation 2, comments we received were from UVA again, and they made comments that if there is a specific school official for whom information should be shared with, it may be helpful to just use the term school mental health professional. Based on this feedback, staff added the school mental health professional or school counselor to recommendation 2. In recommendation 1, these recipients are already listed. So for recommendation 2, they're put in red. So in recommendation 1 original, these recipients were listed. In recommendation 2, they were put in to mirror that. The Legal Aid Justice Center states that they would support recommendation 2 with changes, and they stated that the following changes should be made. That 1, under either recommendation, affirmative parental consent should be required as opposed to default information sharing and an opt-out option. 2, the inpatient facility should notify the elementary school only if the child still poses a risk of violence or physical harm to self or others at the time of discharge. And the legislation should provide a remedy if the child's information is shared without parental consent or disseminated improperly. Additionally, VACSB reiterates their point made earlier, stating that if narrowly drafted to exclude diagnostic or treatment details, such notice would comply with HIPAA. However, the same discretionary and opt-out language leaves the ambiguity and potential inconsistency in practice. Finally, if you go back to VHHA's comments on page 2 of your matrix, you will notice that they compare draft recommendation 1 to draft recommendation 2 and state that recommendation 1 seems to have less risk as it requires the Department of Education to create safeguards, to place safeguards around the proper use of the information obtained and prevents further disclosure of the discharge plan beyond the purpose for which disclosure was made. So based on this feedback, staff inserted the enactment clause that in recommendation 2 that is identical to recommendation 1. Previously, the recommendation 2 said schools should have guidelines in place. Now it says in red that DOE is to create guidelines to place safeguards around the proper use of the information obtained. The remaining comments are additional public comment on these studies, and they're from the same commenters. We heard from UVA, Liz Fuller, who you heard on the previous topic, gave her comments that I agree that parents should be provided the option to give consent before their child's medical records and information are disclosed. And Legal Aid Justice Center shares the process and what they believe could be the benefits of further information sharing and working with the hospitals. And VACSB makes a recommendation to include school training and development of standards in further recommendations. So Madam Chair, that is everything.
Okay, thank you, Mr. Egan. We do have an opportunity for public comment on this decision matrix. Again, the public comment would be limited. Each person would have 2 minutes, and you would be forewarned, or the buzzer would go off. Ms. Atkinson, has anybody signed up for public comment on this specific agenda item?
Madam Chair, no.
No, okay, all right. I do want to say that, of course, these recommendations had been circulated publicly, they had been available on our website, so there was much opportunity to comment in writing, as was the case with our earlier agenda item. Okay, colleagues, the debate is with us, or the discussion's with us. I think this has been worked over pretty well, but I'm interested in your comments, if you have any. Okay, are we comfortable with a motion? The motion would be that we would endorse the draft recommendation as presented with all the red marks, because you integrated responses to, I think, very reasonable comments. And the next step would be legislation would be drafted to implement this very secure sharing of information when deemed necessary. This is a topic that has come to us from various stakeholders, and I did work with, it was a bipartisan bill, I worked with Senator Obenshain for quite a while in the last session. Yes, Delegate Coiner.
Madam Chair, I would make a motion that we endorse the draft recommendations with the changes that have been made in the document based on public comment.
Okay, motion has been made and seconded by Delegate Tata. I think that gets us to a very good place. One of the advantages of having the Commission on Youth, like other study commissions, delve into recommendations is we have a chance to vet them before they become a legislative proposal, so that very much helps move the process along. Delegate Shin.
Thank you, Madam Chair. Sure. I just have a question about recommendation 2 before we proceed with this.
Sure.
If that's okay. Because the concerns I saw and read in the public comments now is they're talking about the opt-in, opt-out for parental consent in giving this information. From what I can tell under the recommendation side, it says that the amendment shall just require the facility to give the parent reasonable advance notice with an opportunity to decline, but that would be an opt-out option as opposed to an opt-in option. And so I'm not sure that the concerns and the comments about that are addressed in this language. And so while I don't have an amendment to make to clarify that, I just wanted to raise that is a concern for me, and I'm not totally comfortable moving forward
Point
here.
that out. I mean, you would be more comfortable with the opt-in, I would take it.
Yes.
Because of the direct relationship. I will ask Mr. Egan, would you please respond to the question?
Sure, Madam Chair. So I did share the comments, and we did hear public comment, including from the VACSB, that opt-in authorization would take care of some of those concerns. That is a potential direction and up to the will of this commission to go.
Well, I think I would have to agree with Delegate Shin. It sort of forces the parents to focus directly and actively, as opposed to opting out, where sometimes it's a bit more of a passive type of action. I don't see a problem with the opting in, do you? It's another layer of protection, or it's posed in a different way.
So, Madam Chair, an opt-in authorization would likely be read as a stronger parent protection.
And child protection. Delegate Shin, I'm taking that to be a recommendation on your part. Okay. Is there a second on that? Commissioner Babichenko.
I had a question. If we're opting out or we're making it an opt-in, does that mean a parent can basically decline to allow disclosures even if there's a finding that there's a risk that's posed? And I understand that nobody's releasing children if there is violence in that moment to themselves or others. But if we're in the situation, I think under prong I, where the minor is requiring additional educational services, such as assistance in staying on a discharge plan to prevent them from relapsing and becoming a danger to others, which is kind of always the concern that we have. Not that in the moment of discharge, they no longer meet the criteria, but they could decompensate without the proper support. Does that mean a parent can opt out to that disclosure and now the schools are not going to be aware to provide that support? That's my question, I think, to staff.
Madam Chair, Commissioner Babichenko, so in practice, an opt-in authorization by parents would operate so that a parent would have to sign a release at the hospital.
So if the parent did, but the parent could potentially not do that and not sign, and then this communication does not happen? Is that my understanding?
Madam Chair, Commissioner Babichenko, yes. So under the recommendations as they're drafted, the process would be the release of information would happen, the notice, or the conversation with the parents would occur, and the parents could opt out. Under the discussion about an opt-in authorization, the hospitals would have to get the parent's signature to release the information.
Understand. Thank you.
Any further questions?
I do not have any further questions.
Okay. Senator Marsden.
Thank you. I think Delegate Shin is correct in that opt-in, pretty much guarantees proper communication, whereas sometimes with these kinds of things, an opt-out provision, might be something that is overlooked, and people just did not know that they had that opportunity. And this puts it in the affirmative, where you actually have to sign something, as opposed to, well, you never said anything, so we assumed it was okay. Just allows for confusion when you do an opt-out as opposed to an opt-in.
And I would just remind colleagues, this is just one additional piece of information that probably the FAP team is already aware that the child perhaps needs services or is getting services. So this would be an additional piece of information. Delegate Coiner, did you have your hand up?
Yes, thank you. I understand the concerns, but I will make the opposing argument because it's in two-part, right? It's providing information if they need additional educational services or they pose a risk of violence or physical harm, either of which I think is important for the child involved in the first one, right? So in the first one, if a parent chooses not to opt in and you have knowledge that they need additional educational services, you've just taken away, because a parent chooses not to sign an opt-in, any chance they have. That's a one-time shot versus you're required, if you don't opt out, to receive those, to be told, the school division's told, you need to give a child these educational services, and a parent can always go and say, no, I don't want them later. But you've just eliminated the conversation about those educational services, and no one's responsible once the parent doesn't opt in to go back and demand that those educational services are put in. So I think in number one, you're setting the student up for not having those, and the parent having to fight to get them after the fact because the school division isn't put on notice your child's entitled to these educational services, which a lot of them are likely going to be in the area of special education in particular, in the area of therapeutic services. I could keep going on the list. So I think it's setting parents up when they're overwhelmed and their child is leaving care to miss an opportunity versus it being placed on the school division to do that. Two, I think in the second series, where if it's the or poses a risk of violence or physical harm, again, we've given the parent the opportunity to opt out and say no. But one, if we say you have to opt in, and again, you don't, and the child does something, I do think it places an increased risk on parents for accountability, for liability, quite honestly, if something happens and they chose to not say anything. But two, I think we also have to keep in mind, we have school buildings full of lots of other families and children who are relying on us to ensure that their kids are safe at school too. So I would feel much more comfortable with it remaining that the parent has to opt out in both instances, because I think it actually protects the child from an educational services perspective and from a safety perspective in both cases. I understand the concerns that have been raised both in committee meetings and otherwise, but I think there's more likely the good that will come from it being the way it was currently set up. That's my opinion.
I appreciate that. You know, the argument that was made, I think, for having it opt-in was, you know, we don't want to label children either. We want to be very careful about information that's, especially medical information that's shared regarding a minor. And that was the argument that I think leaned towards opting in. There's some serious arguments on each side of this. Yes, Delegate Shin, would you want to thread the needle?
I don't know about threading the needle as much as, I think that I hear what Delegate Coiner is saying, and it seems like there's two tracks here. One is around information being discharged if the student requires additional educational services, and then there's a track here if that student is deemed to be posing a risk to themselves or to others, and it feels like maybe the answer is to try and do it differently. I'm not sure. However, I might feel comfortable moving forward with this if we were able to put in language that provided a remedy for, let's say, because right now there is no remedy, and that's pointed out by LAJC's comments here. If the school or if the facility does disclose information and this parent did opt out, then what recourse is there for the parent to then say, like, that wasn't what I asked for, and this now is, like, what's the remedy there?
Mr. Egan.
Madam.
Okay.
Go ahead.
And Madam Chair, Delegate Shin, the opt-out is the recommendation is written would occur at the hospital. So the remedy would be with the hospital. But if that is still something you're comfortable with, staff could draft that up.
So, Delegate Chin, do you want to summarize, or Delegate Coiner? Okay.
So, thank you, Madam Chair. So I think if you rewind and go back to the opt-out, but there's a requirement that opt-out, that the parents are fully informed of that opt-out, and there's a consequence if that is not what happens, that's what we would be ensuring, that the liability is there if parents are not informed of their right to opt out.
So there has to be some insurance.
Because I think what we all want is that the parents fully understand the decision before them. But I think what we equally don't want is for something to slip through because they don't understand the consequence of opting out. So I think you're better off that the school gets they don't opt out, and the school gets from the hospital saying, this child should receive these education services, because then the parent will have that, which will empower them in their IEP meetings, in their school transition plans. And again, at any point, they can always say no along the way, that they don't want those services. But I think it gives them the tools, and they may not know that. They may not have somebody knowledgeable in the process to say, this would help you advocate for what you know your child has needed if you have it. And that's where, so I agree that if we can move it in that direction, that would be my amended recommendation, is continuing with the opt-out, if that's a friendly amendment, Delegate Shin.
We've amended Delegate Shin's recommendation, but I think, Mr. Egan, why don't you tell us what that recommendation is that I want to ask for?
So the recommendation as stands is for recommendation 1, and to incorporate the changes in red. And then I want to read it properly. That the legislation should provide a remedy if the child's information is shared without parental consent or disseminated improperly.
That would be correct. And we're still retaining that.
Yes, Madam Chair.
Is that your understanding? Retaining the opt-out language with yeah, the articulated requirements. Understand what this for? Okay. Motion has been made and amended. All those in favor of the amendment, there was a second. All those in favor signify by saying aye. Aye. Okay, now the chair heard unanimous agreement on the amendment. Is the chair correct? Chair is correct. Okay. So now we need a motion. I would like a motion to just adopt as amended the proposal before us. Okay, motion has been made by Delegate Coiner, seconded by Senator Marsden. All those in favor signify by saying aye. Aye. Okay, chair heard a unanimous agreement. At any point, as you know, commissioners, you're welcome to abstain or vote no. But as it stands, it will go down as a unanimous vote. Mr. Egan, are we finished?
That concludes my presentation.
Okay, thank you. We have one more item, colleagues, and it's the Office of the Children's Ombudsman, the Relief of Custody Work Group. We're supposed to get a brief presentation. And Mr. Reynolds is here. Thank you for joining us.
Good afternoon, Madam Chair, members of the Commission on Youth. I'm Eric Reynolds, I'm the Director of the Office of Children's Ombudsman. Great to be here. Thank you for the invitation to come to present. Have some visuals just to make it a little easier to understand what we're talking about today. But I want to take you back to last year. As you may recall, the Commission on Youth conducted a study in response to information and concerns raised about the number of relief of custody petitions being filed by parents and other custodians of children asking the court to be relieved of care and custody of the children. My office also received a number of complaints where it seems like there were an inordinate number of petitions filed for parents or caregivers looking for relief of the care and custody of their children. And so the commission did the study last year, including conducting listening sessions throughout the Commonwealth to hear about these cases, go to the localities, to go to the stakeholders, to find out more information about why these petitions are being filed, who's filing them, what are the circumstances, how are communities dealing with them, and what are the outcomes of these cases. Out of that study came some recommendations, which the commission took a look at and approved several of them. One of them was a legislative amendment to 16.1-277.02 that goes into effect January 1. Part of that legislation was this direction here that you can see on the screen, where my office was directed to hold a work group to discuss a couple of issues that came up during the discussions, during the study, and in the recommendations from the commission. Particularly, the work group should look at the factors, determine what factors a court should consider when they determine that there's good cause existing to grant a petitioner's petition for relief of care and custody of a child. The directive also wanted the work group to explore the potential benefits and considerations of raising the standard of evidence for granting temporary relief of custody from the current standard of preponderance of the evidence to the higher clear and convincing evidence standard. So those are the two directives that the work group took a look at. I convened the work group with the members that were directed to be part of this work group. We met 3 times virtually, June 5th, August 14th, and October 14th. We had robust discussions, especially from the judges that were participating, to discuss these two issues, the factors for good cause and the standard of evidence. I'm going to go over the standard of evidence first. This came from discussion that came out of the study last year that some folks had considered that the relief of custody petitions were too easy, that there were some parents or caregivers that were seeking relief of custody and care of their child. It's sort of like it was sanctioning abandonment, abandoning their child, abandoning their responsibilities of caring and caring for their children. And so I think some members of that were participating in the study last year were concerned about it being too easy. And so it was discussed that the standard of evidence may be increased. Maybe we do that, maybe make it a little bit harder. However, after further discussion and exploring the benefits and the considerations about raising that evidentiary standard, we came to a consensus and concluded that maintaining the current standard as it is at preponderance is appropriate because it does maintain consistency with the standards of evidence that we currently have when a child is involuntarily removed from a home through abuse and neglect petitions, and aligns with the levels of evidence required for those foster care cases for removal, and then the higher standard of clear and convincing when you get to the termination of parental rights or the permanent removal of the children from the care and custody of the parent. And so current standards for relief of custody mirror those standards. And I think it's more when the work group, believe that it is more important to maintain that consistency because of what's at stake, because the higher standard is appropriate for that permanent relief of custody, just as it is for involuntary termination of parental rights. And so the conclusion that the work group came is let's maintain the level of the standard of evidence at preponderance. We had very robust discussions about the factors, and a lot of judges did participate in what they consider already when these petitions are before them. So we took a lot of their examples, and then we heard from other members of the work group that are involved, other stakeholders who chimed in on these, and this is what we settled in. So here are the good cause factors, and again, this was directed by the legislation for us to look at this. The commission can do with it as it pleases if this results in a legislative change and adding these factors to the statute. We put together this language to assist with that if that is the will of the commission to move it forward to be considered by the General Assembly. So the good cause factors include any safety concerns for the child, petitioner, or other members of the child's household. We found out a lot of these petitions are being filed by relatives, maybe elderly relatives, grandmothers, grandfathers, that are no longer able to take care of some of the needs, the high needs of the children that they took custody of. And maybe there's some safety concerns for either them, maybe there's safety concerns for other siblings or other children in the home, or maybe there's safety issues about the child itself. And so that was a universal factor that we all agreed upon, that should be a factor that the courts should consider when these petitions are before them. The second is the petitioner's relationship with the child, and this goes to the fact that a lot of these petitions are being filed by non-parent petitioners. Some of them are parents, and some of them are relatives, other caregivers that were granted custody at an earlier stage. And so what is that relationship between the child and the petitioner? Is it a parent? Is it a non-parent? And whether or not the petitioner is seeking temporary respite or a permanent relief of custody. Those are very important, of course, depending on if it's a parent or a non-parent petitioner. The third one are the services that the petitioner has already tried to get or currently provided to the child, any services through mental health or educational services, efforts made by the petitioner to access those services to the extent to which those services were effective. And so that's a factor that played into this determination as well. The fourth one is the extent to which alternative remedies to relief of custody and care are available, including CHIN's petitions, seeking residential treatment for the child through a voluntary parental placement, through CSA, or the local Department of Social Services, whereby the petitioner retains legal custody of the child, and the hope is that the child will return home after proper treatment. So what other alternatives were considered by the petitioner before coming to court and filing this petition? And then the catch-all at the end to permit judges' discretion for any other kinds of facts and circumstances that may present in a case, such other factors as the court deems necessary and proper to the determination of good cause. So any questions about those first two, the standard of evidence or the good cause factors, before I move on?
I have a general question. As I'm interpreting your good cause factors and I guess my knowledge of the sort of the JDR, these primarily being family court, I guess, or the JDR system, I guess a judge would have the discretion to require the family to access services if services are available in that community. There's a wide difference of the availability of services. I mean, I would hope that even if the family hasn't accessed services before filing the petition for relief of custody, the judge would require the accessing of services if available. Now, that would be up to the discretion of the judge, but how do you think this would play out in most cases?
Well, Madam Chair, that was a topic of discussion in the work group and something that, again, the judges had raised last year as well as this year in our work group, and that leads me to the next, it's a great segue into one of the statutory amendments that we've been discussing. So let me see if I can get, that's not the one that we're going to be talking about right now, but I'll get to that in a second. So to address your comment, it was discussed amongst the work group whether or not we should suggest or recommend a statutory amendment to require a finding by the judge that the petitioner had cooperated with the local Department of Social Services to access services. So there is some discussion about that, and there is a proposal that we're in the middle of drafting. I'm still kind of emailing with the work group members to fine-tune it. That'll come up in our report that is due to you all on November 1st. So I think we've got some language down, but it would address that concern, making sure that that is something that the judge will look at and also can find that the petitioner is accessing services, cooperating with the local Department of Social Services. And again, the policy being we want to try to preserve families when it's possible. We want to make sure that all possible services are put in place to try to alleviate the situation that's causing the petitioner to seek relief of custody in the first place.
Well, I'm glad the work group is discussing it. You know, this was a topic that the Commission on Youth actually worked on last year, and we put legislation in, and I know Senator Suderline was a patron of that legislation. And if I'm just going to summarize a little bit, the Commission on Youth was very concerned that in some parts of the Commonwealth where perhaps services are not as aggressively available, families were asking for relief of custody in an effort to get the child services. We don't want that to be the reason that a family petitions for relief of custody and the child then goes into a foster care situation or if the child is lucky, perhaps a victim kin situation. So Commission on Youth is very sympathetic towards the leaning of maybe having a finding that the family did at least try to access services. based on the conversations we've had and based on past votes that the commission has taken in this area. Just wanted to share that with you.
Thank you, Madam Chair. And, you know, if you recall some of the discussion that came out of the study and the listening sessions last year, there's a wide variety of situations that come up before judges in these petitions. You got parents or petitioners that have done absolutely nothing, but maybe they didn't know about the services that were available, or they were just at the end of their rope and they didn't want to try anymore, as opposed to a lot of parents or petitioners that did try and tried their best, and maybe there were some barriers in place. So you've got that spectrum of petitioners and circumstances that come up before the judges. And so all that was considered in determining, you know, should this be a finding that they're at least require the petitioners to cooperate to try to preserve the family unit and prevent the child from, because a lot of times as a result of this, the children enter foster care system, and, you know, might not necessarily be appropriate for each child. And so what efforts are being made to try to prevent that? So we'll have that report into you by November 1st as soon as we iron out some of those last minute wrinkles. I did want to call your attention to the one thing that came up, if I have just a few more minutes here. In the course of looking at the statutes that affect the relief of custody petitions, there's this one, 16.1-241, which talks about the jurisdiction of the Juvenile Domestic Relations District Courts. And it talks about, it has jurisdiction over a child whose parent or parents for good cause desire to be relieved of his care and custody. Now, as I mentioned, a lot of these petitioners are non-parents, and so there may be a jurisdictional issue. It hasn't come up. I don't think it's been challenged in court, but it was brought up during their discussions in the work group, and we would recommend that the Commission on Youth take a look at that statute and maybe change it to what you see here in the second bullet point, whose parent or custodian for good cause, or like language, similar language, for good cause desires to be relieved of his care and custody, just to cover the petitions that courts are seeing across the state. So I did want to mention to you that at our last meeting last week, we received updated information from the Office of the Executive Secretary and the Court Improvement Program, where their data indicates a decrease of about 11% in the number of relief of custody petitions that have been filed statewide since last October, and a 14% decrease in dispositions of those petitions, with the exception of several localities showing increases in those dispositions. So we did receive some updated information from our friends over at the Supreme Court. And that is my report. If there's any questions, I'd be happy to answer.
Colleagues, do you have any questions or any guidance you would like to give to Mr. Reynolds? Thank you for your work. This is a really important topic, and we're looking forward to your report, which I hope will be delivered to us sometime soon, or?
Oh, yes.
Okay.
Yes, it's
right.
almost ready.
Because it sounds like there may be legislation forthcoming that perhaps the Commission on Youth may want to weigh in on.
Yes, ma'am.
Okay, very good. Senator Sutherland, did you have anything you want? You did yeoman's work.
Appreciate everyone that worked on that, especially our Commonwealth Attorney. And especially appreciate the thoughts. We'll probably be interested in hearing more about, because I know we'll get more questions about the different levels of evidence that's required, because we heard from a lot of folks on that, and that's why we didn't make a decision or change, and we asked you to look at it more, and I imagine there'll be continued discussion, and look forward to seeing what comes up in the remainder of the report. Appreciate what we have so far.
Thank you.
Thank you. Thank you so much. Oh, I'm sorry, Commissioner Babichenko.
I'll just say, Madam Chair, I did serve as a member on the Relief of Custody Work Group, and it was 35 members with expertise on this issue with all the stakeholders. I thought it was critical that 6 of those people were judges, and they were from all over the Commonwealth, so we got to hear a lot about what they were in fact doing and what was happening there. We could tell that there was really a disparity in resources, and that had a big impact. And a lot of these recommendations, I think, are really great guidance, but then there's that last piece on the criteria, page 4, which says that other factors the court deems necessary, which allowed that flexibility for all the judges, and I think they thought that that was very important. And at the appropriate time, I would love to make a motion to adopt the good cause factors to put into code, as well as the statutory amendment on slide 5 as official recommendations of the Virginia Commission on Youth. But at the appropriate time, I don't know if we want more discussion. I'll leave that there.
I'm expecting that we will get a report, a full report, and we might be able to act on this at our December meeting. So, does that work? That work for you? Okay, thank you. And we will take comment, et cetera, et cetera. So, Ms. Atkinson, I think this concludes our agenda. Is that correct?
Yes, Madam Chair.
Okay. Colleagues, do you have anything you'd like to bring up for the good of the order? Okay, hearing none. All right, we have concluded our work for October 21st. Thank you all for attending, and without further ado, the committee shall rise.
This is the Senate of Virginia, Richmond, Virginia.